Before you sign anything is the best time to get a real estate attorney involved in your sale or purchase transaction. Yes, attorneys are known for helping people navigate their rights to exit a contract once a dispute arises, but if you use the order of operations outlined in this video, you're setting yourself up for a smoother, more successful closing experience than if you try to go it alone and loop an attorney in only if a problem arises. Listen to the end for my pro tip on how sellers can select their own attorney, even if the contract calls for the buyer to select the title company who handles the closing. The first opportunity to have a real estate attorney on your side is when you hire your realtor. Whether you are listing a property for sale or searching for properties as a buyer, there's a contract involved, and you should know the finer details of it. Many listing agreements call for the seller to pay commission to the broker under circumstances that may come as a surprise, such as when a buyer makes an offer that you decide not to accept, or on the other hand, when a buyer makes an offer after the expiration of the term of the listing agreement with your broker. The next opportunity to have a real estate attorney on your side is when an offer is made or received. The offer will contain terms such as what company will hold the buyer's escrow deposit, whether sellers are obligated to close out open or expired building permits or cure building code violations, and who designates the title company that will handle the closing. All terms of the offer that ultimately becomes the contract are negotiable, but having an attorney on your side who's familiar with the customs in your county and knows what the terms are that are typically modified or added into the boilerplate contract better positions you to not leave money on the table. In most counties in Florida, the seller selects the title company who handles the closing, but a little known fact is that the buyer is free to select an escrow agent of their own to hold the deposit until the time of closing. And now for my pro tip. When the buyer selects the title company who handles the closing, the seller is not obligated to have that company prepare the documents that they'll sign at closing. In fact, the seller can select their own attorney to prepare their documents and represent them in the transaction, and the title company will waive the fee that they intended to charge to the seller for document preparation. Even if your operations are out of order and you find yourself in the midst of a transaction with questions about the contract that you signed, send a text to 561-225-2676 to set up a time to speak with me.